Good afternoon, ladies and gentlemen. We hope that you enjoyed lunch. Thank you for coming back to our conference. We have the pleasure this afternoon to begin with the first panel, which is named "With the European Union Support, the Notary, a Trusted Third Party for Citizens, Businesses and Institutions." As you have seen previously in the very nice pictures from our seminars, we prepare a wrap-up of the training activities carried out under the program Europe for Notaries, Notaries for Europe. And we have the pleasure to welcome as speakers Mrs. Emmanuelle Cretin-Magan from the European Commission, who is the policy coordinator on European judicial training. She will present us the perspectives regarding the training in EU law for legal professionals. We have the pleasure to say welcome to Elena Shershneva, who is our scientific advisor for anti-money laundering, which was one of the components of our training seminars, and who is an experienced lecturer and expert in combating money laundering, joining us from Vienna. Welcome, Elena. We have the pleasure to have among us Professor Wathelet, Patrick Wathelet, from the Liège University. We had the chance to listen to him in the morning when he took over from the judge Camelia Toader from the European Court of Justice, who apologizes for the breakdown of her internet connection that made actually impossible her further participation in our meeting. But she ensured us that she will make available her presentation, her detailed presentation, for all of us after this conference. So, Mr. Patrick Wathelet, welcome. He is here in our studio, and of course, in the Brussels studio, we have the coordinator of the training activities, of all training activities of the European notaries, and I would say the most European of the notaries, the president of the Brussels Chamber, Mr. Mark Vilmus. Mark, I will kindly ask you to take over the presentation, the coordination of the panel.
Merci beaucoup, Raoul, pour ce beau discours. Et bon, c'est vrai qu'on était tous très tristes que le discours de Madame la juge Camelia Toader a été arrêté, hélas, avec des problèmes d'Internet, qui sont pas notre cause, mais qui étaient la cause des connexions au Luxembourg qui étaient défaillantes. Alors, comme vous savez, la place du notaire dans tous les pays d'Europe est très importante. Si on veut résumer la fonction du notaire, il y a trois aspects différents. D'abord, il y a le notaire qui est auxiliaire de justice, officier public. Il y a le notaire qui est également homme de confiance et également le notaire qui est responsable de la légalité de transactions qui ont lieu entre parties. Donc, vous constatez que le rôle de confiance pour le notaire vis-à-vis des citoyens, des entreprises, des institutions est un rôle primordial. La sécurité juridique des actes en question est également toujours très importante et c'est pour ça que les différents États font confiance au notaire. Le notaire, comme on le dit souvent, est le gardien de l'intérêt public dans le contexte notamment de la lutte contre le blanchiment d'argent. C'est un domaine dont nous avons traité dans différents séminaires de formation dans le cadre du projet que nous avons mené en partenariat avec la Commission européenne. La CNUE et les notaires membres ont organisé 9 séminaires transfrontaliers pour apprendre aux notaires la bonne application de la directive de la lutte contre le blanchiment de capitaux concernant la prévention de l'utilisation du système financier aux fins de blanchiment de capitaux ou de financement du terrorisme. Il faut savoir que dans ce cadre, plus de 600 notaires ont participé à ces séminaires Et on retrouve les pays suivants, la Belgique, le Pays-Bas, la Pologne, l'Italie, la Lituanie, Malte, le Portugal, la Roumanie et la Slovénie. Il faut souligner que tous ces séminaires ont été transfrontaliers, ce qui veut dire que les 600 notaires participants étaient originaires de nombreux pays de l'Union européenne, y compris évidemment les pays organisateurs. Lors de ce programme de formation, nous avons pu former, avec le soutien bien évidemment de l'Union européenne, plus de 5000 notaires provenant de 22 États membres. Cela représente entre 11 et 12,5% de la profession notariale en Europe. Dès à présent, je tiens encore à remercier vivement l'aide de la Commission européenne à ce niveau. On a un devoir de s'ouvrir à l'Europe, puisque, comme dans tous nos pays, on rencontre de plus en plus de gens de différents pays qui reviennent, qui arrivent dans notre pays. Mais, mis à part la problématique du blanchiment d'argent, nous avons également un devoir d'accompagner les notaires donc, dans leur mission qu'ils rencontrent au quotidien les citoyens, à savoir, quand un client vient chez un notaire, en général, c'est pour 4 périodes de sa vie. Il se marie, il achète sa maison, il y a un problème de succession ou il crée son entreprise. Donc vous voyez, pendant ces 4 périodes de sa vie, le notaire est amené à l'aider. Cela nous amène naturellement au droit de la famille, l'endroit par excellence de l'activité notariale, qui a fait également l'objet d'une formation relative au nouveau règlement de l'Union européenne 2016-1103 et 2016-1104 sur les régimes matrimoniaux et les conséquences patrimoniales des partenariats enregistrés. Dans ce cadre, plus de 900 notaires ont été formés pour mettre en application ces 2 règlements et nous avons pu rencontrer les notaires, notamment en Autriche, en Belgique, en Allemagne, en Grèce, en Italie, aux Pays-Bas, Portugal, Roumanie, Slovénie et France. Le droit de la famille a une dimension de plus en plus transfrontalière, vous le savez comme moi. Ce qui veut dire qu'il est indispensable pour tous les notaires de se mettre au courant des nouvelles dispositions européennes. Ça a été notre travail et on continuera dans ce sens à former les notaires. Et nous tenons ici encore à remercier l'appui de l'Union européenne à ce niveau-là. On a réussi, grâce à l'Union européenne, à la consolidation et le développement de la culture commune européenne de formation juridique dans la profession notariale. Nous avons eu la chance de nous adresser lors de ces séminaires aux notariats européens dans leurs langues respectives et d'être accompagnés par différents professeurs et formateurs. J'ai ici à côté de moi maître Patrick Hautelet de l'Université de Liège. Ont également participé Pierre Calais de Lille et Elena Cherncheva de Vienne, qui ont pu ainsi nous guider du point de vue académique et méthodologique dans nos efforts. Le travail n'est jamais terminé. Chaque jour, nous rencontrons de nouveaux cas qui nécessitent une nouvelle analyse. Je suis convaincu qu'avec des notaires mieux formés dans le domaine du droit de l'Union européenne, nous serons en mesure de garantir encore mieux la réalisation dans des conditions de pleine sécurité juridique, et c'est ça qui est très important, des droits fondamentaux, tels que le droit de la possession d'un bien, de fonder une famille. Ce rôle est particulièrement pertinent dans le contexte du soutien du notaire accordé à la mobilité des familles et des entreprises en Europe. On espère que pendant ces 2 années de travaux qui ont été effectués avec la CNUE, ces formations ont pu guider les notaires et leur faire comprendre la nécessité de suivre ces formations européennes. On a fait de notre mieux pour renforcer la connaissance et implicitement la confiance mutuelle dans les systèmes et procédures juridiques d'autres États membres. Nous avons également encouragé la mise en réseau, l'extension des réseaux existants et des outils de mise en réseau des interlocuteurs en formation du notariat et promouvoir ainsi la coopération transfrontalière entre les formateurs nationaux et des institutions de formation des notariats dans l'ensemble de l'Union européenne. Nous avons également eu des contacts avec d'autres professions, et ce, dans le cadre des formations interprofessionnelles. Nous avons pu, en plus des formations, organiser 2 événements bien spécifiques, à savoir un événement de formation des formateurs, s'adressant aux formateurs nationaux et aux personnes clés des différentes centres de formation. Nous avons également une activité spécifique de formation interprofessionnelle à Bruxelles qui s'est déroulée le 6 octobre dernier et qui était, elle, dédiée à la lutte contre le blanchiment d'argent. Évidemment, il y a eu le problème du corona. Corona nous a empêchés d'avoir pas mal de monde physiquement présent, mais hélas, nous en sommes tous, hélas, les mauvais éléments et nous devons vivre avec cette saleté de virus. J'ose espérer qu'à bientôt nous pourrons nous revoir et que nous ne devrons pas nous contenter, comme on vient de l'avoir ce matin, d'une visite virtuelle de la Cour de justice et que nous pourrons y participer de manière physique. Comme je l'ai déjà signalé, sans le partenariat de la Commission européenne, la CNUE ne pourrait pas faire tout ce travail. Donc on a vraiment besoin de leur aide. Je tiens aussi à remercier les différents notariats européens qui nous ont aidés, qui ont investi également pas mal de temps dans l'organisation de ces différents séminaires et qui ont pu également faire passer le discours auprès de leurs notaires respectifs. L'idée que nous avons voulu est de créer des outils d'information aux notaires. Nous aurons la chance tantôt d'entendre Madame Emmanuelle Crétin-Magan, qui est coordonnatrice de politique en matière de formation judiciaire européenne au cadre de la Commission, et elle nous présentera la vision de la Commission pour l'avenir de la formation des professionnels du droit dans le domaine de l'Union européenne. Je crois que j'ai assez parlé et je voudrais directement passer la parole au professeur Watley qui va directement aborder la question qui nous occupe pour ce premier panel. Merci.
Merci, Monsieur le Président. And if I may, I'd like to continue these brief observations in English for the benefit of having a language balance in this roundtable. I'll try to offer some brief observations on what we've learned during those 2 years, very intense years, looking more specifically at the family side of the project, the matrimonial property regulations. A lot has been done, and we actually have we have learned a lot of lessons. I think the most obvious one is that we have to recognize that a lot of good work has been done. It's been very nice over the last 2 years to see how the various notariats in the member states have put a lot of work in preparing seminars and actually have been very creative in finding new ways to ensure that participants would be able to master complex regulations in little time. And throughout the seminars, we've seen the usual gimmicks, such as the quiz. I think in a lot of seminars, participants started to play with the green cards and the red cards and the votes. But notariats have also gone further. I remember one seminar where the participants could use a microphone which was fitted in a small box, and that small box actually, you could throw it away in the audience. So the microphone was circulating among the audience during the whole seminar. And frankly, this is quite innovative, but it worked. So this proves that you can always renew the training methods to make it more effective. After those 2 years, I think it's fair to say that the notaries in the EU are well prepared, and they're well equipped to deal with these two important regulations on matrimonial property and patrimonial aspects of partnerships. And they're especially well prepared because this project came on top of a previous project on the succession regulation. So now, if we look at the legal professions in the EU, certainly the notaries are the one which have invested the most in educating their members to work with these new rules. Wherever you go in Europe, notaries would then be familiar with the choice of law, which is offered by the regulation. They will also be familiar with the habitual residence. It doesn't mean that all the mysteries of those regulations have been solved. There remains some mysteries. Just to give you one example, Article 26 of the two regulations, which makes it possible for a court to derogate from the normal result of the conflict of law reasoning. It's an exception clause. We've spent a lot of time in various seminars trying to find out how to operate Article 26. And even though a lot of time has been invested, 26 does remain a bit mysterious. But notaries cannot perform miracles. If there is still some uncertainty, and there is on Article 26, I think it's now time to pass not the microphone, but the ball to the Court of Justice to clarify the law. So first lesson, a lot of good work, very intense investment by the notaries in mastering these two regulations. I think another key lesson is that throughout the seminars, we've learned that, yes, we have the two regulations, but EU law does not stand alone. In this field of law, EU law is actually an additional layer which comes on top of national law or next to national law. Matrimonial property was not invented by the EU. All member states have their own rules on matrimonial property, and the regulations only offer a coordination of these rules. The regulations aim to make it easier for couples to organize their assets in cross-border situations, but at the end of the day, the actual law and rules which will be applied will be national law. If you have two French citizens living in Germany and marrying in Germany and spending the first years of their marriage in Germany, well, German law will apply according to the regulations. So when you deal with matrimonial property, you deal with a field of law where, yes, the EU has made a serious effort to coordinate the national law, but national law remains applicable. And we have seen that there is a strong diversity. We still have very specific regulations in different member states. Every member state has its tradition. French notaries will talk about avantages matrimoniaux or the famous récompense. German notaries will be discussing the Versorgungsausgleich. Italian notaries will be discussing the prohibition on unequal splitting of community assets. All these traditions exist and we need to take them into account. When we look at this situation of having EU regulations living next to national law, this brings two questions or two elements to my mind. The first element is a very classic element. We look at the situation of those two French spouses living in Germany. According to the regulation, German law is applicable. Now, for a French notary, how is the French notary able to identify the precise content of German law? This is a very old question. It's not a question specific to matrimonial property, and we know that CNUE has done a lot of work in this respect by putting together various online platforms, making information available on the law of member states, information which is available freely. And if we look, I think, at the oldest platform, Couples in Europe, we have today information on 27 countries, available in 21 languages on matrimonial property issues. And I've looked at it yesterday again. It's very interesting and very nice that the information on national law is directly linked to the key provisions of national law. So if you're looking for information on French law, you will be directly able to see the provisions of the French Civil Code. I myself, as an academic, I've been using this instrument as a first reference, and I've always found it very useful. But it doesn't prevent us from looking at it a little bit more critically. And if we do that, this brings to my mind the following thoughts. In the first place, maybe now is the time to evaluate whether these platforms meet all the needs of practitioners. They certainly meet many of the needs of practitioners, but do they meet all the needs of practitioners? And more specifically, one question is whether the information offered goes far enough. Does it offer enough details on those peculiarities of national law? I don't have an answer to that. It's an open question, but certainly given the huge success of these platforms and the investment made by the CNUE, it's worth evaluating the tools. Another question is that these tools are limited to the law of member states. And this is striking because we know that all European regulations are not limited to purely European relationships. With the matrimonial property regulation, a notary in Luxembourg could end up applying the law of a third state, a non-EU state, say Switzerland. Now, Switzerland may not be a good example because identifying the content of Swiss law is not that difficult. There are online tools to do that. But we know that in the Europe we live in today, there are many people living in Europe with very different backgrounds, coming from far away and even further away. So it may be wise to think about gradually opening up the platform to maybe a few selected non-EU legal systems for which there is a need in practice. And I'm realizing by saying this, I'm potentially putting some additional work on the agenda of CNUE, but I believe at least it's necessary to take the time to think about these possible evolutions. Reflecting on how to assist or better assist practitioners in finding the content of the law, the applicable law, is one thing. Another thing is to understand better the relationship between the EU framework and national law. As I've underlined, EU law cannot simply be thought independently of national law. EU law comes in addition to national law. And the Honourable Judge in her presentation today referred to a number of cases decided by the Court of Justice. For those of you reading these cases, you know that the Court of Justice always first attempts to identify the main principles of EU law, but it also takes time to explain the legal system of the member state in which the question arose. So the national law of member state is relevant, and there is an intricate relationship between EU law, which is the framework, and national law. EU law is embedded in national law or otherwise. This brings me to two comments. First, a comment on the method of training. Until now, we've had many seminars, and all those seminars always started from the regulations. And this was quite understandable. These were new regulations. It was necessary to explain the principles of those regulations to practitioners. But if I'm a practitioner, the first question I will have in any matter will not be a question dealing with a regulation. The question will arise in my national law. If I'm a French notary, I may be wondering whether the Société d'acquet, which I'm proposing to my clients in relation to maybe some of the immovables they have, immovable in France and one immovable in Italy, well, how will that Société d'acquet play out in Italy? Will it be accepted or not? So the questioning for practitioners does not start from the regulation, it starts from national law. Hence, my question, should we not flip the seminars? Flipping the seminars meaning, when thinking about new seminars, not take as a starting point the regulation, but start from national law. Because again, the questions asked by practitioners will be asked based on national law, on their practice, on what they know. While all the seminars until now, they've been constructed around the regulations. But now we're one step further, so there is room for innovative practice, and one of that practice could be flipping the seminars. Another thought I want to share with you relates more to the content. As I said, there is a clear interaction between EU law and national law. And we may need to pay more attention to the interaction, but also we may need to pay more attention to national law during the seminars. Because national law is alive, it keeps evolving. I'm just using two examples. We'll take the example of Slovenia first. As far as I understand, Slovenia has adopted recently a new family code, and that family code is a game changer for divorce, because it makes it possible for spouses to divorce without going to court. If the spouses do not have children or minor children, they may divorce simply by going to a notary and agreeing to the terms of their divorce. Now, this is a development of national law, which definitely will have an impact on how assets are split among spouses. So you see, a development in national law may have an impact on the way practitioners in Slovenia have to work with the regulation. Another example is even more recent. You may have heard that yesterday, the French government has introduced a bill in the Assemblée nationale. It's a very large bill, and one of the elements of the bill is a provision which relates to succession, cross-border succession. And what the French government wants to do is to make it possible for a child or a spouse of somebody who died to claim assets in France, more assets than this person would be entitled to under the applicable law, if it is shown that there is a discrimination based on the foreign law, discrimination meaning that this child or surviving spouse would get less assets in another country. So in a sense, what the French government is suggesting is to create a French mechanism which would be able to redress imbalances in the cross-border succession. It's very new. We will need to study this in detail, but it does raise interesting and intriguing questions of whether this is compatible with the succession regulation, and if yes, how this will play out. So again, here you've got examples of national law which it keeps changing and which will have an impact on the operation of European rules. Given this, I think there is room to think about the next generation of seminars where national law will be more embedded in the seminars. We should not think of EU law as something different coming from another planet, which stands really apart from national law. The two are formed together, the law which practitioners need to apply day in, day out. And I think one good method to have more attention to national law in the seminars would be to pay more attention to the documents. Pay more attention to the documents, because at the end of the day, notaries work with documents. They work with contracts, they work with deeds, wills, what have you. The work of a notary is based on drafting, reviewing, explaining documents. And all these documents are strongly rooted in national traditions. Now, from the point of view of citizens, what citizens want is that a document drafted by a notary, say in Luxembourg, can be used in Spain without any difficulty. Free possibility to freely circulate with these national documents. Now, we may want to think about paying more attention to these documents as a way to open our seminars to national practices. Mrs. Sastamoinen this morning talked about building a common judicial culture in the EU. Well, one way to do that, if we want to do this seriously, may be to think about sharing expertise on our respective national documents. Now, let me be clear about this. The goal is not to create uniform European documents. We have a very rich tradition in all member states where notaries work, sometimes a very long tradition, and every national notary has its specificities. But maybe we can try to ensure a better mutual understanding of how EU law works by focusing on the documents, by having seminars where notaries from different member states would share thoughts about documents they work with or documents from other member states, all with the idea of fostering this better mutual understanding of each other's tradition and practice. I realize that I have put a lot of work on the agenda for notaries, but I'm really confident that notaries are up to the challenge. Thank you for your attention.
Merci. Pardon. Voilà. Merci beaucoup, professeur Wathelet, pour cet exposé. C'est vrai que dans le futur, on ne verra plus l'Europe et le pays, mais on devra vraiment travailler ensemble. Et comme disait notre nouveau ministre de la Justice en Belgique, la digitalisation est très très importante à tous les niveaux et je crois que dans ces matières également. Je reviens à ce que j'ai dit là tantôt. Le notaire a évidemment, comme depuis sa nomination, il est un officier public. Ce qui veut dire qu'il est aussi un auxiliaire de justice. Et dans ce cadre, nous avons tous, dans les différents pays d'Europe, rencontré de plus en plus de problèmes avec la problématique du blanchiment d'argent par certains. Et donc, tous les notaires ont, dans les différentes études, rencontré de plus en plus de nouvelles règles à respecter en raison de cette réglementation européenne. Et nous étions très contents de pouvoir bénéficier de l'aide de Madame Elena Cerceva, consultante, et qui a pu nous aider dans ces différents séminaires sur la lutte contre le blanchiment d'argent. Et je lui donne bien volontiers la parole. Merci beaucoup.
Merci, Monsieur le Président, et j'étais très heureuse d'être une part de cet projet très important, and I will proceed in English. Yeah, thank you very much. And it was indeed a very interesting experience because I strongly believe that lawyers and notaries, and especially notaries, as legal professionals, are one of the most effective wheels for the fight against money laundering. And as you already have said in your introduction speech, we live in a time of constant change. So we are currently facing all this coronavirus, which brings again new methodologies, new typologies used by criminals and by money launderers. And so we need the force of every reporting entity, of everyone who is in the boat at this fight against the criminals. And when we look at the fourth anti-money laundering directive, we see very clearly that it's a prevention directive. So it's already in the name. It's a directive to prevent the misuse of the financial system for money laundering and terrorist financing. And this has a very, very important message in it, meaning that every customer, every client that you prevent from entering the sector of taking advantage of your services, which may be misused, is already a success. So we can't measure successful fight against money laundering really effectively by comparing figures, how many people have been brought to court, how many people have been imprisoned or judged for money laundering. But the fact is, how many people could you prevent from misuse the systems for money laundering and terrorist financing? And that again is a very, very substantial matter of awareness within the sectors. And having said this, I would like to point out something that happened at the very beginning of the project. So I was invited to serve as a scientific advisor, as expert for this project. And the first task was to make a training manual, which I did. And the training manual was starting with a wording. It was something like, notaries and lawyers and other legal professionals are very likely to be abused for money laundering and terrorist financing. And one of the first comments that was coming from one of the member state countries was like, we should remove this section from that manual because it wouldn't shed a very good light on the notaries to communicate that they can be abused for money laundering. And that was actually nailing the whole problem that we have with fighting money laundering in the non-financial sector. So we kept this passage in the text, and I would again fight for it to leave it in. And the fact is that the more awareness that people have about the possibility of being misused, the better they are in the position to develop counter systems, to live a very good, high quality, everyday compliance. And reading the reports of the workshops that we had in different European countries, this project was clearly a very, very big success, because there is one common thing that was like, just like a red line through all the reports. And it was this understanding of the own risks. So in one report, we had, for instance, as lesson learned, the finding that, yes, we can be part of a money laundering route, and it's important to have the awareness. And the other very important finding was that we can do it only together. And that brings me to another point. So it was a very, very good thing, I think, that the workshops were not only presented to notaries all across Europe, but we had also a number of cross-sector participations from lawyers, from supervision authorities, also the FIUs who contributed in a very, very good manner through all of that workshops. And I think that that's the right approach to come together, to exchange information, to share experiences, because when you when you are not aware of your risks, then you maybe also don't see the possible doors where the risks can come in. The broader the field is you look at, so if you have, for instance, FIU telling you the experiences they have, or lawyers telling experiences, banks sharing experiences, then you start to see the whole puzzle, and then you are in the position to be aware of the part that you play in that picture. And I think that this was a goal that was clearly reached by all of that workshops. So there were very, very highly interested notaries. There were good questions. There were fruitful discussions. And at the end of each workshop, there was always like an aha effect where you just seen, okay, now we see that we can be misused. Now we see that we can be part of a scheme that money launderers put in place. And it's still a fact that the creation of companies and the purchase of real estates are one of the mostly used typologies, mostly used methodologies. Why? Because you can move a lot of money by only having one business. So it's a very accessible way for the criminals to launder money. And in that case, especially in these fields of expertise, it's really all about prevention. So it's like putting traffic lights and speed limits on the street so that people can cross the street safe. And you can really compare it to the anti-money laundering directive and to the work that you do and the awareness that is built there. And I think that this is also a very important stone that has been built for the future. Because when you look through the anti-money laundering directive, if you look at the developments, then there is one word that is getting stronger and stronger, and that's the third-party reliance. But the third-party reliance can only work if all wheels in the cart are moving in a similar manner. So if everyone knows what's his or her role, if everyone really does the things that are required in a very qualified and high manner. And in discussions with legal professionals, especially also notaries, you often hear that it must be possible that you rely on a bank. But counterwise, when you talk, for instance, with banks, they also say, okay, the anti-money laundering directive is writing here that when money come through a business that where a notary or a lawyer or another legal professional has been part of, then I can rely on that data as well. So you have to keep that in mind. You are not only the one who can rely on others' services, but you also need to be the basis for others, especially banks, to rely on. And I think, and that's really something that I'm convinced of, that successful fight against money laundering and also about the against the emerging threat of terrorist financing can only be as successful as the weakest player, as the weakest part. Because criminals are clever, they change their methodologies, their typologies on a daily basis. They use the weakest part of the whole system to integrate the money into the financial system. And I'm really very happy and thankful that this project added a lot of value, that notaries in Europe are definitely not the weakest part anymore. So that's also something that I see also in my daily work with notaries, in my daily work with governments all across Europe. The sector was the sector is stronger now, and I think that's a really good indicator to measure that the project has been a success. So with regard to the future, what would I wish for? I think that there should be definitely a follow-up maybe on a regular basis, because it was such a worthy work that has been developed here, and so much knowledge has been shared. And this information sharing on an international level should be kept up, definitely. So I think if we keep going the same direction, then it would definitely add value to the fight against money laundering and terrorist financing. Thank you.
Merci beaucoup, professeur, pour ce brillant exposé. J'ai été fort étonné, je vous avoue, quand j'ai participé aux différents séminaires sur le blanchiment d'argent, c'est de voir et d'être tout heureux de voir l'intervention, notamment d'avocats, de juges et également des membres des différents parquets, des parquets fédéraux. Je crois que ces échanges nous ont permis d'ouvrir également les yeux de beaucoup de notaires sur certaines pratiques de certains mafieux qui, hélas, pour lesquels les frontières sont ouvertes. Et je reste convaincu que dans ces matières, un suivi régulier sera nécessaire pour tous les notaires, mais également une coordination européenne à ce niveau. On a déjà ouvert beaucoup de portes grâce à ces séminaires, mais le travail est loin d'être fini. Et sachez que c'est toujours une lutte tous les jours si nous voulons contrer ce genre de personnages dans les différents pays. En tout cas, merci pour le travail effectué et comme on dit, on est appelé à nous revoir, j'en suis sûr. Maintenant, je voulais encore vous rappeler qu'il est important, cet après-midi, vous pouvez participer, poser des questions. Donc, n'hésitez pas à chatter, le chat est ouvert. On prendra note de vos questions et à la fin du débat, on pourra, dans la mesure de nos possibilités, essayer d'y répondre, bien entendu. Voilà. Alors, comme je vous rappelais là tantôt, eh bien, sans la Commission européenne, nous n'avions aucun projet à vous présenter aujourd'hui. Donc, c'est vraiment un travail important qui a été réalisé par la CNUE, mais je tiens ici encore remercier de tout cœur la Commission européenne qui nous a vraiment aidés à trouver le budget pour organiser ces différents séminaires. Alors, je passe la parole à Madame Emmanuelle Crétin-Magan, qui est coordinatrice des politiques et des formations judiciaires au niveau de la Commission de l'Union européenne. J'ai eu la joie de la rencontrer plusieurs fois et c'est toujours un plaisir de voir l'attention qu'elle porte au notariat européen et on la remercie encore régulièrement. Et sans votre aide, je crois que beaucoup de portes seraient restées fermées. Merci beaucoup.
Thanks a lot. Pleasure shared. Thanks for the invitation for the closing conference of the project. It's really nice to hear about what went on and so on, because we are there with the theoretical financial support. We are very happy when CNUE wins a competitive call and with its members to run a project. We also hear about the life of the project with the official reports because the financial unit gives us the information. But it's even nicer when we can see the projects when they happen or hear about the results. So it's a pleasure to be among you today. As you mentioned, it's not the first time that I attend a meeting of CNUE on training. I remember with great pleasure a conference, for example, which took place in Rome a few years back. Well, today we're not in Rome, we're online. I'm attending from the office that I created for myself at home these days. I'm in Brussels. And actually, I wonder about the participants. Where are the participants from? I know there's a participants list, and we have names of participants there. But could the participants put in the chat where they are at the moment, in which city, just to show all of us how European today is. I will start and show the example. So I will put Brussels, and actually I specify that I am at home teleworking. And you can also let us know, are you at home or are you in the office? How is it for you? And while you do that, I will present you more boring topics, of course, because my speech is a bit more institutional from the Commission point of view. I will present you the new package, the training part of the new package adopted last week by the Commission to modernize the EU justice. And again, before starting, I would like to express my appreciation of the good partnership with CNUE and the European Commission. We care about notaries training. The notaries help secure the effect of EU law in areas that are relevant for individuals, for businesses, as we heard examples just now, be it succession, mediation, insolvency, anti-money laundering, and so on. So training of notaries is of high importance to us. And I was very happy to hear about the renewed commitments of President Ruskas this morning, of course. Slide 2, please. This is the technology issue, you know, I adapt, and thanks a lot for CNUE technicians for their help with this, because they will actually be my little hand during my presentation of today. So as you heard this morning, if you were there and if you attended and paid attention, Mrs. Astamoinen explained that in the training package, there are 3 elements. And I will present these 3 elements now. So I will start with the report on European judicial training with the 2020 report. So next slide, please. And first, I would like to thank CNUE and its members for their contributions to the report. Again, this year we had replies from all members, so it's very much appreciated. I don't know if you have seen the report before, but that's why in the presentation I highlight a few figures. Overall, the results are good. The report shows that in 2019, more than 180,000 professionals were trained. It's slightly less than last year, but still among the highest levels that we have reached since 2011. We supported as EU with different types of EU funds, training of more than 42,000 participants, so almost a quarter of all the participants in training on EU law. So that's nice, and we hope the trend continues. Next slide, please. So I turn to notaries, and the profession confirms good levels, good training levels on EU law. However, there was a slight decrease of the percentage of notaries attending training on EU law since, well, for a couple of years actually. The figures are still good. I mean, they are both 25%. So, and that's far above the minimum 5% that had been set by the old strategy. But the objectives have now changed with the new strategy, and I will present you just now. So I turn now to the new strategy. Next slide, please. So to give you the context, the previous strategy was covering 2011 until 2020. So it was elapsing at the end of this year. So as a result, we prepared a new strategy with a wide public consultation. We also had a conference of stakeholders back in 2018. We published an evaluation last year of the old strategy. And here again, I'd like to thank CNUE and its members for the valuable contributions that we received in the different steps of the consultation, and including the participation of some of your members in the expert group on European judicial training. And here I'd like to thank in particular Cindy Fouquereur or Raoul Radoy, whose name I saw in the list of participants, if I'm not mistaken. So the training strategy is based on 4 main elements, if I can summarize it in this way, which cover content, audience, methodology, and shared responsibility. So I will present each of these 4 strands. And of course, in the strategy, we also touch upon some elements that are even more important in today's context of pandemic, teleworking, virtual meetings, and virtual training activities. So first, the new strategy calls for the national training curricula to address all key areas of EU law. And as Professor Watley was mentioning, all that should be embedded in national law training because all is linked all the time. The strategy also calls to provide a flexible response to emerging and continuous training needs related to EU law. So when new topics arrive, that the offer is adapted. So there's a need to continuously assess the training needs of the notaries and to have a flexible reactivity on the part of the training providers. As Director General Sasta Moinen said this morning, one of the flagship actions of the new strategy is to consolidate a common European judicial culture, because ultimately it also helps us consolidate the rule of law, fundamental rights, and to put together participants from different countries, as you have been doing, also helps consolidate mutual trust in cross-border proceedings. Training should also help the practitioners, and including notaries, to be fit for the digitalization of justice and to know how to use the practical online forms, the tools that exist today, but there will also be other trainings required in the future because many new tools are even developed as we speak. We also added another element in addition to training on EU law as such, and we go beyond legal education with the inclusion of something that we call judgecraft. That's actually the set of skills and attitudes of justice professionals that they need to have to perform their tasks. Professionals' skills training is a national responsibility, and that should be embedded in the national and continuous training of the notaries. And as far as the European Commission is concerned, the Justice Programme will support financially training on professional skills, but only when it is combined with training on substance, with training on EU law. Next slide, please. So secondly, the new strategy targets a wide range of justice professionals. It targets actually all the justice professionals that are involved in the administration of justice. It's mainly judges and prosecutors, but also notaries and other justice professionals. There is a specific focus in the new strategy on boosting judicial training for young practitioners. It's essential, it's been said before, but it's still valid that new practitioners understand their role as EU practitioners from the start of their career. Also, mainly EU practitioners are targeted, but we also want to involve more practitioners from the candidates to the EU, for instance. So we hope that many governments from the Western Balkans will choose to join the future justice program that will start next year, because this would enable CNUE, for example, to include participants from its observer members in the projects once the country has joined the justice program. So to be followed. And the new strategy, as I hinted at before, sets new objectives regarding training of professionals. Instead of having an overall target, like in the previous strategy, covering all practitioners with the same aim, this time, we set more tailored objectives, tailored to the needs of the professions and also to the level of training that the professions had reached. So the objectives that was set for notaries is to train yearly 30% of notaries on EU law by 2024. This may sound high, but what does it mean in practice? It means that roughly any notary would attend a training activity on EU law every 3 years. And when you word it like that, I do not find that it's that much. It might be a minimum if the person wants to keep up to date with developments with case law and so on. To attend training regularly is actually important for the quality of the practice and of the advice given to the clients. And if I may, if you look at the figures in the 2020 report, you will see that several notariate are already at 90% or more. To be followed there as well. But all in all, the target was almost reached. A few years back, you had 29%. So the challenge will be more, not so much to reach the percentage, but to ensure to maintain it, to have to instill a constant culture of training and training seen as an investment by the notaries. But I'm sure you can succeed collectively. Next slide, please. So the third element focuses on the training methodology. To have high quality, effective training, it's essential. Otherwise, the practitioners will not feel like going to the training if it's not useful, if it's not interesting, if it's too passive. The training activities should ensure that the participants learn by doing and that they are not just passive listeners during the training. The different digital tools that help support virtual training nowadays have to be put to the full use. So yeah, a good training methodology also applies to e-learning. And there is, of course, an explosion of e-learning during the COVID-19 pandemic. But e-learning tools and courses are needed in general. In any case, it can help maintain the high level of participation. It can also maybe help answer new training needs for which a quick answer is required for the practitioners who do not have time to wait for 3 months for the next seminar. So the e-learning offers have to be attractive and also need a good interactive methodology so that the participants feel engaged and this will help them remembering what they learned and apply it hopefully in the future. It's even more important, I believe, than for face-to-face. Because you do not only want to have many participants registering in the e-learning. You want the participants to actually finish the e-learning and not drop out before the end. So it's important to have good expectations, time frame. We have to keep in mind that there are more distractions for the participants that can take away the participants from the screen. It's more than in face-to-face training. So e-learning should be interactive, and there are different tools. There are interactive videos where you have to click and choose, and depending on your choice, then something else happens. Another video comes up, and then you have to choose something else, and so on. And there you are learning what the consequences are of your choices. The quizzes are known. Scenario games are less used, but they are also very efficient ways of learning. You could even think about virtual reality training. Um, and engage the participants even online. Use breakout rooms, make them chat together, make them discuss, make them turn on their cameras, see each other. And supporting material can be sent before, after, during. It can be podcasts. It can be passive videos there. It can be audio recordings, things like that. And I know that CNUE is about to start developing an e-learning. You mentioned it. It's part of the new project that you were awarded. So congratulations for that. So I really strongly suggest that you contact specialists of e-learning to help you build it. Maybe you can reach out to other professions and see what they've done. I would recommend to be bold, to try and aim for the top of what is possible nowadays. Use the fact that there is financial support, and there will be again in the future. Next slide, please. So the last element, the fourth strand, is about the shared responsibility that we have between the member states, the training providers, the national professions organizations, the European level ones, and the EU. We need the continued commitment of all to implement this strategy. So we rely on the CNUE, we rely on CNUE's members, and as I said, I was happy to hear the renewed commitment of President Ruskas this morning. But we also rely on the individual notaries themselves. Notaries need to take the time to attend training. They need to see training as an investment in the future and not a loss of time away from their practice. And this applies also to the owners of big notary practices who need to factor in training as working time of their collaborators. At the same time, the Commission will continue supporting CNUE, notably with financial support. So we'll use the future justice programs and the other funding mechanisms. For instance, the future citizenship rights and equality and values program, though it's a bit specific, a bit more oriented towards fundamental rights, but it includes a training priority, and it happens that its budget has been significantly increased by the European Parliament. But in any case, I congratulate CNUE and its members for the different successful projects that you have implemented so far. And I can only invite you to use the opportunity to apply again for the co-funding of your projects in the future. You're only starting one, but we will also be there to help e-learning developments and so on in the future as well, because it can be costly. And since we provide up to 90% of co-funding, you may enjoy our financial support. Next slide, please. I'll finish my presentation with the European Training Platform. So this is actually an online tool. It is a search tool that was launched last week as well on 2nd of December. It's at the service of practitioners who want to train themselves on EU law. So if you go there, you will discover training courses on EU law that are organized in the EU in different languages, not only English, even if English is the majority, at the moment at least. So it advertises training courses on EU law, but you can also find there training materials for self-learning, handbooks, checklists, podcasts, e-learning from previous projects. At the moment, it is in a test phase. Our intention in the test phase during 2021, our intention is to make it user-friendly for all justice professionals, including notaries. So we welcome all feedback and ideas for improvement. Don't hesitate to send any. Also, we would be happy to advertise training material of CNUE on the ETP. In this context, we need to focus on the user friendliness of the websites where the courses are stored and advertised. It's a prerequisite for a link from the ETP. The website or the video, the podcast, the checklist, the way it's presented, it should be self-explanatory for the notary, for the practitioner who discovers it and opens it. It should be standalone, and practitioners should find the document practical straight away. And that's how we want the resources on the ETP to be. We want to collectively encourage the always busy professionals to enter the ETP, to stay on it, to browse it, to search it, and to benefit by it. And finally, you have the link here, so I hope that CNUE can send the PowerPoint presentation to all participants, because I encourage you to advertise the ETP widely, spread the word, please. Send the link to your colleagues, put it on websites, on the website of CNUE, the website of the notarial chambers. Let's make it a success together. To wrap up, just before finishing, I will recall. So European judicial training should help practitioners answer their training needs when new topics emerge, and to be agile users of the new digital tools. European judicial training should reach at least 30% of notaries per year by 2024. The training methodology should benefit by the best existing tools to ensure interactive training that engage participants, including for e-learning. And for this, lastly, we need the commitment of everyone, CNUE, the national chambers, but also the notaries themselves. Next slide, please. Thank you very much for your attention, and I'm available to answer any question you may have. I wish you a good conference.
Merci beaucoup, Madame Crétin-Magan, pour cet exposé. Et c'est vrai que je vous rejoins sur beaucoup de points, notamment sur le fait que nous devons absolument développer tout ce qui est e-learning. Je crois que c'est important. Et c'est vrai que depuis le mois de mars, que le problème du corona est apparu dans tous les pays, eh bien, de plus en plus, on a appris à dialoguer avec notre PC beaucoup plus souvent. On a appris à travailler, comme aujourd'hui, par vidéoconférence, alors qu'il y a quelques années, je peux vous confirmer qu'il n'y avait quasiment aucun notaire qui utilisait les vidéoconférences. Tout se faisait en présentiel. Maintenant, je crois que les travaux futurs seront certainement tournés vers tout ce qui est e-learning, en maintenant quand même également des séminaires, parce que je suis aussi convaincu que l'aspect humain et aussi le fait de rencontrer la manière et de pouvoir discuter avec les autres notariats européens est quelque chose d'important. Je vous rejoins également sur votre exposé quand vous dites bien qu'on doit s'ouvrir également aux pays qui ne sont pas membres encore de la Commission européenne, les nouveaux pays, si on peut le dire ainsi. Bon, je crois que c'est en effet une sage décision que nous devons également prendre, puisque, par exemple, pour le blanchiment d'argent, les frontières ne s'arrêtent pas à l'Europe. Et hélas, on voit d'autres pays intervenir régulièrement dans nos pays respectifs. Donc je crois que là aussi, on doit s'ouvrir. On a pensé certains pays de l'Est. Bon, moi, j'aurais tendance également à ouvrir la porte vers les pays du Maghreb, puisqu'on a énormément quand même de compatriotes qui sont d'origine tunisienne, marocaine, etc. Et je crois que c'est toujours utile d'avoir également l'avis de ses confrères. Voilà, en tout cas, merci beaucoup pour votre intervention et pour votre aide si précieuse. Et je suis sûr que nous reviendrons au niveau de la CNUE avec des idées pour nos prochains séminaires et nos les prochaines formations qui seront organisées. Voilà, alors je vais passer peut-être à la parole à Raoul Rodeuil pour la question du chat, parce que je crois qu'il y a quelques informations techniques qui doivent être données.
Merci beaucoup Marc, merci beaucoup à tous les intervenants pour leur discours excellent et très enrichissant pour nous. J'aimerais bien demander à la régie s'il y a déjà des questions qui sont apparues dans notre rubrique questions et réponses.
Nous avons effectivement une question qui nous vient d'Italie et la personne souhaiterait savoir si les activités de lutte contre le blanchiment seront éligibles dans le prochain programme de formation de la Commission européenne.
Emmanuel.
Yes, they will be eligible. It's funny because I understood the question as will anti-money laundering be covered by the new CNUE project? So that will be a question that I will send back to
me.
Raoul Radoy himself. Okay. But as far as the European Commission is concerned, yes, anti-money laundering will remain part of the possible topics of projects that we will support financially. Yes, thanks.
Thank you very much. Thank you very much, Emmanuel. Well, if you allow me to just a few reflections. Thank you for presenting us the new strategy and congratulations for the kickoff of this new strategy on the 2nd of December. It is, well, we had the privilege to accompany this process with my colleague Cindy, of course representing always and consulting ourselves with our members and with Mark regarding the European judicial training priorities of notaries, and we thank you very much for taking always into consideration our points of view and the specificities of the notarial profession. I wanted to announce that, well, it's not new, you all heard that we would like to respond to these new challenges that were set up. 30%, it's not nothing, it's a lot, and we are going, of course, to inform tomorrow during our General Assembly of the presidents, all the presidents, about these new targets of the European Union. I think that Commissioner Reinders will himself address our presidents on this issue. So it is a really important policy aspect in our activity in the future. And we would like to respond to this challenge by setting up an e-learning platform for the European notaries. First of all, to respond also to the Italian colleague, to Antonio, first of all, we will treat issues related to the data protection, family law, and company law. So these seem to us immediate and imminent to be treated in a European systematic manner. And indeed, this would respond also to the lack of time, let's say, of legal professionals when having to travel, let's say, abroad to assist to a seminar or to take a day off in order to participate to a seminar. But what we try to ensure in our new projects, and I would like to express again the gratitude for the trust that the Commission conferred us in this new endeavor regarding the e-learning, we would like to ensure complementarity with the classical activities, with the face-to-face activities, to build up on the success of these seminars that we had, 20 in the last project, as you heard, which is not nothing. Again, 20 seminars in all over Europe addressing all the countries, notaries from all the European countries. This is indeed a performance that was only possible, as Mark said, with the support of of the European Commission. So this is, in a nutshell, let's say, our intentions. Let's hope that with that we could meet the expectations of the European Commission. And thank you again to all the participants, and to you, Emmanuel, to you, Professor Watley, to you, Elena, and Mark, to you as well for the coordination of our activities in this field. Thank you, and I would like to invite you to have a 10 minutes coffee break and then to take over with the second panel of this afternoon.